The government is asking a fundamental question that could reshape gun rights in America. Can they take away your Second Amendment protections simply because you've done something they don't approve of, even if you haven't hurt anyone or proven yourself dangerous? The Supreme Court just agreed to hear United States versus Hermani, a case that forces them to answer who exactly counts as the people protected by the Second Amendment. Does it mean only perfect, law-abiding citizens as the government defines them? Or does it mean all Americans unless the government can actually prove they're dangerous? At the center of this case is a federal law, 18 U.S.C. Section 922 G3, which makes it a crime for any unlawful user of controlled substances to own a gun. The Fifth Circuit Court of Appeals threw out charges against Mr. Hermani, ruling that the law can only apply if someone is actually intoxicated at the exact moment they possess a firearm. Just using drugs sometimes isn't enough, they said. Having drugs in your house isn't enough. The government must prove you were high right then and there when you touched that gun. The federal government appealed straight to the Supreme Court, which agreed to hear the case. Now the Trump administration is arguing that the government should be allowed to take guns away from drug users even when they're completely sober. Mr. Hermani himself isn't a sympathetic figure, and that's exactly why the government chose to push this case forward. The government loves cases with bad facts and bad people because it helps them get the rulings they want. Mr. Hermani is a dual citizen of the United States and Pakistan. In 2019, border agents searched his phone and found messages suggesting possible fraud connections to Iran. He had close ties to Iran, including a brother attending university there. The FBI started surveillance and eventually found evidence of drug use and possible dealing. When the FBI raided his home with a warrant, they found a handgun along with marijuana and cocaine. Mr. Hermani admitted to occasional drug use and claimed the drugs were his. The government charged him under Section 922 G3. Mr. Hermani fought back, arguing that after major Supreme Court decisions like Bruin and Rahimi, the Second Amendment doesn't allow blanket bans on gun ownership for all drug users. The trial court judge agreed and dismissed the charges. The Fifth Circuit upheld that decision, based on previous cases saying it's unconstitutional to strip gun rights from someone just for occasional drug use. The key factor, they ruled, is whether someone is intoxicated at the specific moment they possess the gun. The Department of Justice is making several arguments to defend the law. First, they claim history supports disarming dangerous people, pointing to old laws restricting guns from drunk people, the mentally ill, and others considered dangerous. They argue habitual drug users fit this same category. Second, they insist this isn't a permanent ban since someone who stops using drugs regains their gun rights, making it just a temporary restriction. Third, they highlight disagreement between different circuit courts and argue the Supreme Court needs to settle the question definitively. The government strongly disputes the Fifth Circuit's rule requiring active intoxication. They say historical laws about vagrancy, civil commitment, and insanity restricted people based on their status and pattern of behavior, not what they were doing at one specific moment. Therefore, history supports taking guns from habitual drug users even during sober moments. The problem with this case is its terrible plaintiff. When you have bad facts and a bad person at the center, it's hard to get a clean, broad ruling that protects rights. The Supreme Court usually tries to narrow such decisions as much as possible. That's exactly what might happen here. The court could make a very limited ruling applying only to Mr. Hermani's specific situation, avoiding broad statements about drug users and gun rights generally. But there's danger even in a narrow ruling. The court might use language that lower courts latch onto and expand. Remember the Rahimi decision? The court mentioned a more nuanced approach to the Second Amendment, and now lower courts are using that language to uphold all kinds of gun restrictions. The same could happen here, where even if Mr. Hermani loses, the court might say things that damage Second Amendment rights going forward. Strip away all the legal complexity and bad facts, and the fundamental question becomes clear. Does the Constitution protect only so-called law-abiding, responsible citizens as the government defines them? Or does it protect all people unless the government can clearly prove they're dangerous? Think about what's at stake. If the government wins, they can revoke your constitutional rights based on behavior they dislike, not because you hurt or threatened someone, but simply because you did something illegal. Today it's drug users. Tomorrow it could be something else entirely. The ruling won't just affect one man in Texas. It will set Second Amendment boundaries for years to come, potentially impacting millions of Americans who have used drugs at some point. This case will also clarify how the Bruin and Rahimi standards work in practice, adding more detail to the constitutional framework those landmark cases established. The Supreme Court will hear oral arguments this term and issue a decision that every gun owner needs to understand. The principles at stake go far beyond one bad guy with drugs in his house. They go to the heart of who gets constitutional protection in America and whether the government needs to actually prove someone is dangerous before stripping away their fundamental rights. Claude is AI and can make mistakes. Please double-check responses.